Yes, this is Dr. Della Welch, and this is tape 2 of Constitutional Law. We are continuing the amendments to the Constitution. You remember that amendments 1 through 10 are called the Bill of Rights. Now we will look at the 8th Amendment, and that was passed in 1791, and that prohibits cruel and unusual punishment. The current state of the law is that capital punishment is not cruel or unusual. There are several states which provide for capital punishment. However, there are other states who don't, and this is the area that we may see changes in the law at the United States Supreme Court. The next amendment I want to go over is the 10th Amendment, and this states that those powers not delegated to the federal government, and we can put in parentheses, Article 1, Section 8 has the enumerated powers, and are not forbidden to the states, are given to the states. And I have a little mnemonic: who stole my wife? So when the states are acting pursuant to the 10th Amendment, they are acting pursuant to the state's police power. They are acting for the health, safety, morals, and welfare of the citizens of the state. So I always say the governor, before he goes to bed and before he says his prayers, he tucks a copy of the 10th Amendment under his pillow. Who, we take the H from who for health, and then safety, stole, my, and that's health, safety, morals, is the M, and then W is the welfare. Now, the next amendment I want to stress is the 13th Amendment, and this was an amendment in 1865 that was a product of the Civil War, and this abolishes and prohibits slavery. Many have said, well, if we had the 13th Amendment clear back in 1865, why did we need Title VII of the Civil Rights Act in the 1960s? And the reason is the states were doing a subterfuge of the 13th Amendment, and they were having these Jim Crow laws that greatly discriminated against the African American population. The 14th Amendment also came out of the Civil Rights Movement, and it has two parts. One is the equal protection, meaning you do not treat people similarly situated differently. And it also has a due process clause. You cannot deprive someone of life, liberty, or property without the due process of the law. And that is usually a notice of what charges may be against them and a hearing. And again, the Jim Crow laws that these states enacted discriminated against the African American population, and so that was why we needed Title VII. So our country says if you want to discriminate and violate the 13th and 14th Amendment, you're going to be paying for it. You're going to be paying big fines and big fees under Title VII. So that stopped a lot of discrimination in our country. Now looking at some other amendments that are heavily tested that I wanted to emphasize. One is the 19th Amendment, and that occurred in 1920, and that was the amendment that gave women the right to vote. You remember when Hillary first ran for president, she would always have her mother along on the campaign, and she would emphasize when her mother was born, women could not vote. So in 1920, women did have that right to vote. And another important amendment I want to emphasize is the 26th Amendment. And this gave 18-year-olds the right to vote. This occurred in 1971 during the Vietnam War, and the feeling was if these people these young men are old enough to fight for their country. They should be old enough to vote. And President Obama was one who really saw the power of this 26th Amendment, and he won many of the young people at the college age level and won the presidency. So I don't know what will happen in terms of our current candidates if they will utilize the vote of the 18 years old. So also I wanted to emphasize Article 4 and the 14th Amendment, and this contains the Privileges and Immunities Clause, and this prohibits states from enacting laws that unduly discriminate in favor of their residents, and it applies only to their citizens. One thing you need to know in terms of the discrimination laws is the state has a compelling state interest in avoiding racial discrimination. So if there wants to be any discrimination, it has to have strict scrutiny. But if we are in other areas such as gender discrimination, you can use like rational basis or an intermediate scrutiny. So in addition to the scrutinies, you need to know about the balancing tests. And none of these constitutional rights are absolute. We balance. We put what is the state's interest on the left side, and then we put, for example, on the First Amendment, what is the burden on religion. So you do a balancing test, and if the rule is found to be too burdensome, then it will not apply. Such as it used to be the Indians, they would smoke peyote, and it was felt, well, the state has an interest in people not using drugs. But then they said, what's the burden? Well, the burden is real heavy on their religion. They believed they'd be damned, and when they saw the Great Spirit in the sky, that they would not be able to go to heaven. So the Indians won that one. However, then the Indians invited all these other people to help to do the peyote, and the state said, no, you've gone too far now. So remember that you do the balancing, the state's interest and the burden on the private interest.